Good morning, everybody. Welcome to the Conservative Home, Crime and Justice Conference. I'm Angus Parsad-Wyatt, Chief Executive of Conservative Home, and it's my pleasure to welcome you all here today and to all those following along on the live stream this morning as well. Today we'll be diving into some of the most pressing issues facing our criminal justice system, from reforming our legal processes to addressing the challenges of sentencing, prison capacity and reoffending. It's a crucial time to be having these conversations, especially as we look towards making changes that can improve both public safety and the fairness of our justice system. We are starting with two important panel discussions this morning. The first, Transforming Justice from Courts to Victims, will tackle the urgent need to reform within our legal system, focused on how we can better support victims and address the backlogs in our courts. The second panel, Smarter Sentencing, How Can We Streamline Prisons and Reduce Reoffending, has a very long title which basically does what it says on the tin, but we'll explore the sentencing bill, discuss its implications and look at how we can implement strategies to make our correctional system more effective and just. Wrapping up our sessions this morning, we'll hear from Alex Chalk, who is the Lord Chancellor and Secretary of State for Justice, in a keynote that's set to bring together the threads of all of our other discussions and look ahead to the future of justice in the UK. Our panels today all include a range of government ministers, experts and sector leaders, all bringing their unique perspectives to the table. They're all giving freely of their time to be with us here today, so please do give them your full attention and respect as we move through the morning. A few brief housekeeping points before we begin. There are no fire drills planned today, so if an alarm does sound, please exit quickly via the door you came through at the back there, make your way out of the main front door and assemble just outside the Home Office across the street outside. Please ensure, and just take a moment to check now, that your phones are on silent. We obviously don't want any interruptions during the discussions this morning. We do encourage active participation throughout the day. There will be opportunities in each of our three sessions to put your questions to our speakers. If you are selected by the chair of the respective panel to ask a question, please do so respectfully and please keep it clear and to the point. If it starts with, it's more of a comment really, or your life history as to what brought you here today, the chair may well ask you to sit down and we'll move on. I'd also like to take a quick moment to thank our partners today, Australian Skills, who are sponsoring our first panel. We're delighted to be joined by some of the team here this morning, and Carlisle Support Services, who have got their great exhibition stand at the back for you to explore during the break as well. With that, I look forward to our first panel discussion. At the end of this session, there will be a short comfort break whilst we reset the stage for the second panel. The longer refreshment break and teas and coffees and things will come after the second panel and before the keynote a little later on. So thank you again for joining us. Let's move forward to what I'm sure will be a series of engaging and informative discussions. But for now, please join me in welcoming our first panel to the stage. William.
Thank you very much, and good morning. My name is William Atkinson. I'm the Assistant Editor at Conservative Home, and I'm very glad today to be hosting Transforming Justice from Courts to Victims, a panel that will delve into the pressing need for reform within our legal system. Last year we discovered the news that the court backlog post-COVID is approaching 65,000, a record high. Whereas in the period since 2010, the MOJ has seen its funding cut by 25%. We've seen half of magistrates' courts close and a third of county courts close, whilst the public currently believes, according to a YouGov poll, by 73% that sentencing should be harsher. And so, with that backlog in place and with public demand for swifter justice, I want our panel today to work out what needs to be done to make our courts work as effectively as possible in not only sentencing, but in preventing future crime. And on that note, I'm very happy to be joined today by Mike Freer, the MP for Finchley and Golders Green and the Minister for Courts and Legal Services. Next to me we have Laura Ferris, the MP for Newbury, who is the Minister for Victims and Safeguarding. To my left, not only politically, is Sir Robert Buckland, the MP for South Swindon and former Lord Chancellor and Secretary of State for Justice. And last but not least, Nama Zarug, who is the founder and director of Astrea Link Skills, who has very kindly agreed to sponsor today's panel. The format shall be rather simple. I shall ask each of our panelists an opening question, and then perhaps one or two supplementary questions before turning it open to the audience. I would like to repeat our Chief Executive's comments. Questions, not statements, please, so we can get through as many as possible. Thank you all for being here today. And without further ado, I shall kick off by asking Mike our opening question, which is, with the ongoing challenge of the court's backlog, what immediate steps is the government taking to alleviate the pressure on courts and ensure timely access to justice?
Thanks, and I'm not sure if that means I'm on the far right.
Oh no.
That would be an unusual position for me. What we're doing is that there is a number of factors as to why the courts are under significant pressure. But in terms of, we are recruiting, we've recruited 1,000 judges over all jurisdictions over the past year. We'll do the same this year. That doesn't mean a net gain. That's obviously sometimes that's replacements for people who retire or leave the profession. On top of that, we are keeping the Nightingale courts open. We are doing a lot of work with our partners across the criminal justice system to try and ensure that what I call the sludge in the system, make sure that the cases go through more swiftly. We're also investing £120 million a year for the next 2 years to ensure that our courts are resilient, because being truthful, we did kind of not spend enough money on the court estate, and we lost too many sitting days because of unplanned maintenance. So all of that combined means that our court estate is resilient. Our judiciary are working flat out. In fact, the number of cases disposed of is currently up about 12%, but the receipts are up about 14%. So more judges, better courtrooms, better case management, but we're also dealing with a shortage of defence counsel, which causes trials to continue to adjourn. And at the same time, we have aggressive policing. And in many cases that is correct, but in some areas that does mean we have a lot of cases going into the system that perhaps ought to be dealt with out of the court system.
Thank you very much. And Laura, can I turn to you now, please? Is how does the government plan to bolster safeguarding measures for vulnerable individuals within the justice system, from the point of first reporting a crime through to the conclusion of any trial?
So first of all, I think it is just worth going back to, I think, what is the first question here, which is about backlogs. And I don't think you can look at the issue of backlogs in a vacuum. I mean, I know I'm very keenly aware I'm sitting next to the former Lord Chancellor who had to take very difficult decisions during the pandemic. But fundamentally, the decision that was taken during the pandemic is that criminal trials in the Crown Court would proceed with full juries of 12 people. And that was a really difficult thing to do during periods of national lockdown and social isolation and all the rest of it. And I think the reason that decision was taken is because it was felt that a jury trial is the cornerstone of the Article 6 right to a fair trial. And my view, 3 years on, is that that was the right decision, not an easy decision, but that that was the right decision. And when you look at the backlog, I think it is worth saying a couple of things first of all. If you look at the magistrates' court, where, you know, the vast bulk of criminal matters are determined, actually the backlog's pretty much gone. They're back to normal. If you look at the Crown Court, yes, there is a backlog of 65,000, but it's worth reflecting. When we came in 2010, the backlog was 48,000. That was a sort of starting position. Before the pandemic, we got it down to about 39,000, and now it's 65,000. So yes, it's high, but it's important just to calibrate that and recognise it's not high from zero, it's high from about 40,000. In terms of victims, I think there's a few points that I would make, and I think actually some of the biggest progress in the last, actually since I've been an MP, has been in the support that's given to victims. Since we came in 2010, we have quadrupled the amount of money that we're spending on victim support. And we've also we're putting on a statutory footing at the moment through the Victim and Prisoners Bill, the Victims Code. And I can tell you, it is night and day compared to where it would have been in 2010. You know, in 2010, if you'd been a victim of crime, you'd have gone to the police and had your interview, gone home, and then maybe a year later got a phone call saying, next week it's your trial, and you're up, and you're a witness, by the way, and you're going to speak to a courtroom in front of a jury, and that's your involvement. That is completely different nowadays. Nowadays, you have rights, statutory rights under the Victims Code. You have the right to be informed about the trial. You have the right to have a familiarisation exercise in court. In certain cases, you might even meet the CPS who will explain to you how and why they're prosecuting. You have the right to give a victim impact statement that will be read out if the defendant is convicted, will be read out ahead of sentencing and will be part of that process. You have the right to be contacted when that defendant is going to be released from prison and told, what that release will look like. You can even make your own remarks about what you want that to look like. For example, a restraining order or a no-go zone around you if that's the nature of the offence. So that's really important. And then in some of the most sensitive crimes, rape, domestic abuse, we're on track now to have more than 1,000 independent sexual violence advisors. We call them ISVAs and IDVAs, domestic violence advisors. And what they are people, lay people, who will hold the victim's hand from the minute they go to the police all the way through the criminal justice process. And they are funded by the MOJ, but recruited in a more informal way. They're not a part of any official designation. They're not lawyers. They're supporters. And what we know from working with them and working with victims groups is that if somebody is a victim of one of those crimes and is supported by one of those people, the chance of them remaining in the system and seeing it all the way through to a proper, fair criminal justice conclusion is much higher. And then the other thing I think that's really, final thing, I would say, that I think is really important, which is quite new actually, is that for people who are victims of rape, you can give your evidence through the Section 28 procedure, which means you can go to court ahead of trial and have a private hearing where you're where you're examined in chief and cross-examined in this confidential environment, and then afterwards your evidence is played at the full trial, but you don't have to go, you don't have to confront the perpetrator. And so all of that, I think, has changed the landscape of victim support.
Splendid. Thank you very much. That was very comprehensive. And now I'll turn to Nama. From your experience as a solicitor, what are the most significant barriers to justice for victims? And how can these be overcome with legal reforms? And sort of following on from what Laura said, what have you seen change for the better perhaps recently, and what still needs to change?
Well, first of all, thank you everyone for having me. I am a solicitor. I've been a solicitor for about 20 years, and I'm in criminal defence up in Liverpool in the northwest. And there have, in my 20 years, the big thing that victims are facing at the moment, and will continue to face, I think, for a long time, is delay. And delay in the criminal justice system means that victims are frustrated. Often they feel it's not worth the effort for them to get involved. And where there are complex issues to be decided at trial, and rightly there needs to be proper protections put in place for defendants, because as you say, jury trials and the trial process is the cornerstone of our criminal justice system. Often victims feel as though the perpetrators of crimes are getting a lot of care, a lot of assistance. They have very clever, often described in newspapers as expensive legal teams. I deny that. We are not expensive legal teams at all. Legal aid is very poorly paid, but that's a whole other subject. And victims can often feel that the perpetrator of the crime against them is getting all of the assistance, and they don't essentially have lawyers of their own. And then when trials are over and perpetrators are convicted, victims can also feel very dissatisfied at the sentences that are imposed by the courts. And I think a lot of that comes from a unrealistic expectation of the sentencing regime and what the purpose of the sentencing regime is. Not everybody is going to go to prison. Not everybody, we're never going to bring back hanging. And the retribution, the aspect of retribution that sometimes victims and communities expect from the sentencing regime just isn't there. And I think the rhetoric around sentencing does need to change. The importance of non-custodial sentences, why they are passed, the need for non-custodial sentences, and ultimately the very positive impact that those sentences have on society. We do need to ensure that victims are better informed about that. Otherwise you end up with a wholly dissatisfied victim and somebody that wonders why they bothered getting involved at all. So I'm glad, it is great to hear that we're spending more time and money supporting victims through the system. That is massively important. I would like to see victims better informed about what to expect from the trial process and what to expect from the sentencing regime.
Splendid, thank you. That importance of information, I think, is a topic that we will be, returning to, especially in the later questions, because it often strikes me that to an outsider or to somebody who's, alas, caught up with having to deal with it, the criminal justice system can seem terribly complex. And as you say, perhaps that gives people expectations that are perhaps too high, even with various other sort of physical limitations. But last but not least, I shall turn to you, Sir Robert. And actually, I mentioned your sort of leanings earlier simply because just before you became Lord Chancellor, you spoke very eloquently at my university on the principles of one nation conservatism, which, alas, I think convinced me at the time, but I believe I've sort of somewhat drifted away from subsequently. Nevertheless, I would like to, I know, I apologise for letting you down, Sir Robert, but nevertheless, reflecting back to that period in your life, your tenure as Lord Chancellor, and what you may have achieved, in office and what's happened subsequently or beforehand. What reforms do you still believe are needed to modernise the UK's legal systems and improve outcomes for victims?
Well, first of all, I've never regarded myself on the left of conservative politics. Perhaps the party's moving in a way that isn't going to help anybody. My politics has always been pragmatic, Tory, and the heart of the Tory party. So it's for others to ask themselves why it is they think another direction is appropriate. It certainly won't win elections. To come to this event is rather a pleasant experience in the sense that we are dealing with very serious matters, but looking at the content and substance of the debate, I'm not sure we would have had this sort of debate only a few years ago. I see a phrase for the second session, smarter sentencing. That was the title of the white paper that I published when Lord Chancellor, because I was determined to move away from this rather negative rhetoric about tough and soft and to talk about smart and stupid, because that's frankly the best way to approach criminal justice, having practiced in it myself for many years, like Nama. At the coal face doing criminal legal aid mainly in South Wales. And I'm not quite like Simeon today, but listening to my colleagues, my ministerial friends who are working so hard to deliver policies. They're all policies that I'm very proud that I helped to either initiate or move along. ISVAs and IDVAs was something that was a great passion of mine that I'm glad to see really yielding fruit. The Victims Bill, again, was work that I started in order to make sure that victims don't just have a code, but they have statutory rights that can be enforced, and as Nama says, more access to information so that expectations aren't raised in a way that is unrealistic, and that can lead to a lot of hurt and misunderstanding. There are some basic challenges to the system, both intrinsic and extrinsic. I just want to deal with the second one first. When I was in Cabinet, I always said to colleagues that every department is a criminal justice department. In other words, the acts or omissions in health, in education, in welfare, all had a downstream effect upon the criminal justice system. It meant that problems that weren't addressed earlier in life or earlier in the stage would often become very expensive criminal justice issues, most notably in the field of young offenders and indeed in the field of drink and drug and other addiction. And whilst I do not believe for 1 minute that just because you might be from a certain socio-economic background, you're bound to end up in the criminal justice system, some of the confluences that we see within the system cannot be ignored. So why is it that we have a large number of people who have autism or some form of neurodiverse condition in the system? Unless we ask that question and try and deal with it, then I don't think, A, we're going to divert people away from a life of crime, and B, we're not going to cut crime, because reoffending rates amongst the population, certainly the parts of the criminal justice population, the short-term sentences, younger offenders, are alarmingly high. And that's why the call for evidence that I carried out when Lord Chancellor on neurodiversity now has resulted in coordinators in our prisons who can better identify the needs of inmates and help them to help themselves, in other words, to get them on the path of rehabilitation. So a lot of these challenges are extrinsic. Intrinsically, I think that we have to absolutely adhere to the jury system. It is the best system yet devised for people to be judged by their peers. But using technology in a cleverer way has to be the answer. And you see, the court system's only at one end of it. Look at the investigative process. For a victim, it's not just the year or so on average that you might be in the court system. The Lord Chancellor will come and tell you about that later, and he's right. It's the 2 or 3 years before that of investigation, when an arrest is made, an interview is held, a statement is taken, or a recorded statement in a sexual allegation, and then, because of the sheer weight of what's on these things, it takes months, if not years, to analyse all the material. Now, we've got to find cleverer ways in which to do that. We have to harness machine learning. We've got to improve the way in which technology can analyse evidence in a way that is safe, that is agreed by the parties, and frankly, which ultimately is supervised by the court. That's got to be done. It's happening in other walks of life. Criminal justice should be no exception. And I'll say this finally. I do think that when I was in charge, I found it very frustrating that the Lord Chancellor, who is responsible for the money and the political accountability, didn't have as much of a reach into the administration of justice as I think they should have. And that's not to say politicians should start taking over court decisions or usurping the role of independent judges. No, it's about us having the space and the time and the thinking space to actually help with the administration of justice, as opposed to a very, very busy senior judiciary who I think are being asked to take on far too much. Because unlike in family law, where you see judges coming forwards with sensible operational ideas, which colleagues in the Ministry of Justice work with, things in the criminal justice system are very reactive. And we're not seeing enough of that initiative, I think, coming from professionals. That's because a lot of them would say they're very hard-pressed and very busy, and I know that from my own experience. But we do need that operational expertise to come forward with sensible, practical proposals that can improve things. We saw it with the digital case management system. If you go into a Crown Court now, you see very little paper. That's because everything is online, and perhaps that would surprise some of you. But I think now in the analysis of evidence and the sifting of evidence, technology really has to start to take a central role. So looking forward to the discussion ahead, and I'm really glad to hear a lot of the plans that I had to rebuild and revive and recover the system are carrying on, despite the fact, that wasn't an assault, despite the fact that I'm no longer there to oversee it. Thank you.
Splendid, thank you very much. And I'd actually like to continue on that similar theme with Mike and then Laura, which is asking how technology and digital innovations can be used to streamline court processes and improve access to justice for both victims and defendants alike. Mike.
Just finishing off on I joke from what Robert said, I joke that actually my job in the MOJ is I'm a facilities manager, in that my job is to provide the court buildings and some staff to help run them. But actually what goes on in a courtroom is outside of our control, because the judiciary run the courts, and quite rightly. But it does get frustrating when we see opportunities for improving productivity that we kind of have to just plant a seed and hope that the judiciary will pick it up. Now, to be fair, the Lady Chief Justice and the Senior Presiding Judge are incredible good at reforming and trying to get to the nub of what is making things slow down. But to get to the point of the question is what we're doing in the use of technology. The most obvious way is during COVID, we really embraced remote hearings. We didn't shuffle defendants around the country to sit in court just to listen to barristers argue or to listen to solicitors argue. They could do that from their cell. We don't necessarily need a duty solicitor from London to drive 2 hours up into the Midlands to provide legal advice in a police station. Sometimes face-to-face advice is appropriate, sometimes it can be done remotely. But post-COVID, we rode back. We've seen a significant rowing back from the use of technology and remote hearings. And so one of the things I'm currently doing is squeezing the estate, looking for a spare space in our courtrooms that I can turn into a remote hearing room. Two benefits. One, I don't have to have solicitors and barristers shuttling around the country either for what could be an hour, let alone defendants. But also it means if I've got a judge sat in the eaves of a building doing a remote hearing, it means I've got a courtroom free for a full trial. So we're investing quite a lot in trying to not just putting the technology there, but also working the judiciary so that they adopt it. But then one of the other big wins is the use of AI is a slightly broad topic because it can cover a multitude of sins. Certainly, machine reading is the rather obvious solution. So I'd have to tread carefully here because I don't want to set hairs running, but our legal profession rely on what they call whales. So because criminal legal aid is not brilliantly paid, they rely on the big cases where we pay to read what's called pages of prosecution evidence. So we almost pay per page, which is a bit dated. A lot of that can now be done by AI. And my view is if I could stop paying people to read bits of paper, if you're doing a complex fraud case, you could be reading hundreds of pages of phone numbers, or a machine can do that. Let's take the money away from reading bits of paper that a machine can do and spend it where the solicitors and the barristers can add value. So two things, using technology in courts where we don't need physical presence, and using AI or technology to take some of the drudgery out of what our legal professions and judges have to do.
Splendid, thank you. And Laura, did you have any further thoughts?
Well, I think I'm probably just going to augment what Mike said because I agreed with everything. But I think, look, one of the realities, I think, of court processes, and I was a barrister before I became an MP in 2019, is that the justice system is quite slow to catch up. The last big trials I was doing, both sides had, 9 lever arch files in front of them. It was go to page 1024, everybody takes file 6 out, turns to it, reads it, forests worth of photocopying, and clerks having to do manual handling training courses because when they're carting the files around it could cause them a back injury, and that was the case in most courts 5 years ago. So we've got to be realistic about that. Mike's quite right to say that there was an acceleration of sort of online justice during COVID, which is not as much, has slightly come off. And I think just 2 points I'd make. It isn't economical or practical or pragmatic or necessary for young barristers to go schlep across the country for a 1-hour case management hearing. We've got to be totally realistic about that. All of that should be online. And actually, I think when you're talking about criminal justice, most non-contact type offences could be resolved through online proceedings. Yes, of course, the quality of justice matters. And the MOJ is going to have to do a long-term job in sort of ensuring the technology's there. Not cheap, not easy, but I think imperative actually now, because I think you could really streamline and accelerate a lot of justice through that process. The only other thing I'd say on AI, and I don't want to, I'm not a guru on this at all, but somebody like Richard Susskind is doing the most interesting thinking about it, I think, in this kind of country, really. And he says that, we aren't far away from developing models where lots of disputes, civil disputes, take everything that's dealt with by the small claims court. And it's easy just because of the title of that court to think, it's just they don't deal with the big stuff. But my God, there is nothing more intense than a neighbour dispute where they're disputing who owns that bloody tree at the bottom of both their gardens. Those things are fiercely fought. But he is already at the stage where he's thinking there is a model where both sides would put in their respective documents, the deeds, the maps, the this, the that, and a computer would resolve the issue of ownership or liability or duty of care. And whilst I think we're probably some way from human beings being willing to outsource to the machine that fundamental question, I think we have to accept that it's in the ether now and it's coming, and we'd be better to embrace it rather than resist it.
Thank you. Though I tend to find the more I learn about AI, the more worried I become. So I hope we're not too close to having sort of robo-judges deciding even the most basic cases. But perhaps sort of returning then from the more ethereal world of technology to the more sort of nuts and bolts philosophy of our legal system. Nama, I'd like to sort of ask you that one of the things that we've been talking about the most so far today, it strikes me, is speed. Obviously, with the court's backlog, the idea of trying to sort of catch up and overtake and get justice delivered as swiftly and as fairly as possible for victims. But, I mean, what balance should we strike? You know, looking at sort of, as an outsider in, as it were, on sort of government policy, etc., what balance should be struck between expediting legal processes and ensuring sort of fair trials and thorough trials?
Well, obviously there does need to be balance, and one of the things that is frustrating for us in defence that's often not recognised is that where the police or whatever investigating body is prosecuting the case have been on their case for 5 years, 8 years, sometimes on complex frauds. The idea then that you can throw a 55,000 page case at me and expect me to be ready in 2 weeks, it's unfair, it's a nonsense. It doesn't feel fair for the defendant either. They know that they have been under investigation for many, many years. The part that the defence play in a criminal investigation is much smaller than I think people understand. We're involved at the interview stage. We have a limited amount of disclosure at that point, but our real involvement comes when somebody is charged. And yes, we are speeding along to trial, but there does need to be a careful balance. And of course, justice needs to feel, the defendant needs to feel that they have been dealt with fairly. And if I may, I'd just like to come back to this issue of technology. I have 2 young children. I worked from home pre-COVID. I loved working from home during COVID. It was fantastic that finally the courts had caught up on technology. It was great for me to put a sign on the door so the children understood that I was in a hearing and could come in. It was brilliant. And yes, we've gone backwards, and it is a real shame. But the courts are getting better. The technology doesn't always work. I'm sure you've heard that before from lots of practitioners. It would be great if it worked. But the biggest flaw in the system for me is when defendants are in custody and everybody is congratulating themselves about being digital and paperless, and that's fantastic. You cannot take to a lot of prisons will still not permit you to take a laptop in. So we are still printing off reams and reams of paper. Defendants will feel extremely unsafe sometimes at having a physical copy of their papers in the cells with them. And where you are doing a video link conference with a defendant in custody, the system doesn't allow you to play, for example, digital evidence, CCTV footage, body cam footage. So we're still in this nightmare where I'm having to constantly explain to judges, some of which haven't been in a prison in a long time, that I am frustrated because although the technology has reached this level at the court, still not good enough. We're still way down here as far as the prisons and the police stations are concerned. So some sort of cohesive, joined up thinking between all parties who are involved in the criminal justice process, that would be fantastic, obviously.
Yes, it strikes me as printing off reams and reams of paper is, if nothing else, not particularly environmentally friendly.
It's not environmentally friendly. It's expensive. It's not environmentally friendly. We have to pay somebody with a law degree to stand at the photocopy machine to do it. It's a complete waste of resources.
Yeah, sounds like that. Sarup, did you have any thoughts before I move things open to the audience on that sort of basic question of speed versus?
Many thoughts. Nama's just illustrated the old adage: the criminal justice system is only as fast as its slowest component. And no matter how good you might get courts and prosecutors, the defence aren't in that position. It's through no fault of them, as she's explained that they are, then the system is going to go at the pace of its slowest participant. And that's why I was very pleased that video hearings increased from about 400 a week and phone hearings to 20,000 during COVID. But I always knew that the hearing wasn't the beginning and ending of that digital involvement, because it's what happens before that and after that which is important, which is why many judges would say video hearings don't actually encourage that face-to-face discussion where issues can be boiled down between lawyers and a lot of the efficiencies can be achieved. You get a lot of that sense from the judiciary about the limitations of video hearings. However, I have to say that I think if you accompany them with other digital innovations, then not only will familiarity improve the process, but actually the quality of the hearings will improve as well, because it's what goes on in the hearing that matters, I think, more than anything. Now, I think the references to machine learning and technology are very important. I'm doing a lot of work on this at the moment as a senior fellow at Harvard Kennedy School, looking at the impact of AI on the ethics of justice, because I don't think we're thinking enough about that. And whilst I think Laura is absolutely right, and the Master of the Rolls, the head of civil justice in this country, is evangelical about the need to incorporate machine learning into money claims and civil claims, I think ultimately we've got to ask ourselves, can the machine actually replace the sort of reflective judgment that judges and indeed juries make about the quality of evidence, the credibility of witnesses? I think that we're still way off that. I think even if we got to a generative system of machine learning that could do that, there's a question of public confidence. Would you be content with a machine deciding whether or not you should be guilty or innocent of a serious crime, whether you should go to prison, for example, or would you want your fellow human beings to do that? Now, we've got to ask these questions now. They're not sort of sci-fi. They've got to be addressed now, because I think if we set the guardrails now, I think within that we can operate confidently and accept an increasing use of the machine in the process, because the machine won't just be, wigs and gowns and quills and pens with IT. It will change the very nature of the process itself, and we've got to be very open-eyed about that.
On what Robert's just said, not many people realise that legal services is one of the UK's biggest exports. And actually, I lead on that. And talking to one of our partner countries, it was fascinating and scary at the same time, because a senior judge in a Supreme Court of an overseas jurisdiction wanted our help on how to build an automated sentencing model. So basically, they type in the details of the case, and the computer issues the sentence. Now, he said, but then obviously you have to have a judge at the end to say, chopping someone's head off for shoplifting is possibly a bit harsh. But it did scare the hell out of me. Great innovation, but scary at the same time.
Absolutely. Now, I've given a lot of thought to this, and where you've got sentencing guidelines, there is a formula. However, at the end of it all is something called judicial discretion, and the fact you've got a human being in front of you with all a myriad of different factors that the pre-sentence report will have covered, and you've got to have that residual discretion. I think you can build automated decision trees that don't need all these databases with all the bias problems that they bring, but ultimately they're only going to speed up the work of a busy judge on a Friday in Birmingham, as I've done myself doing lots of sentences. Ultimately, the judge will still have to do the brain work of analysing what they've heard and whether or not that sentence, even if it crosses the threshold, should be a suspended sentence or a community order. That human element is, I think, still an essential part of it, but I think decision trees could be a very useful way of helping to speed up some of these processes.
Splendid, thank you very much. Now I'm going to turn things open to the audience. So if you've got a question, please put up your hand and I will direct Abigail to you. The gentleman here at the front, first of all.
Thank you. Chris Nelson, Police and Crime Commissioner for Gloucestershire. I'd like to follow up on something Sir Robert said when he was Lord Chancellor, that you wanted to be able to reach more deeply into the administration of the court system. My question really is, should police and crime commissioners have more powers when they chair their local criminal justice board? At the moment, we have convening powers, but we don't have any legal powers. And when I talk to our court's representatives, we talk through a whole range of things, but I don't have the same holding to account powers that I have over my constabulary. And I personally believe that having more powers would be one way of trying to get more scrutiny and control over what's happening in our courts.
Thank you. Sir Robert, would you like to take that one? And then either Laura or Mike, if you've got the
It's great to
first.
see you here. You know, I used to go to my Wiltshire Criminal Justice Board meetings with the then PCC because I wanted to delve into what was happening there. I'd say a couple of things. First of all, I think PCCs are the perfect convenience. I think they should share local criminal justice boards across the country, so I'm glad you're doing it. Secondly, I think whilst we had everybody in the room and a lot of data, with respect, it didn't seem that people knew what to do with it. And no criticism. You had the probation service there, a lot of information about offenders, but nobody just really knew what then to do next. And that's why I think nationally it was important that the Criminal Justice Board in London, chaired by the Lord Chancellor and the Home Secretary, actually set some objectives that PCCs could follow. That the and crime element of your job is, in my view, the most important bit, because what you can do with that evidence is develop policies together with the other agencies to help cut crime and to prevent crime. So if you see a particular trend, I don't know, in antisocial behaviour in Swindon, well, put your resources into trying to deal with what on earth's going on there with young people, for example. Now, on your point about accountability, I'm glad you mentioned reaching back into the police. I think there are problems with PCCs wanting to get perhaps too much involved in the warp and woof of the courts, to be honest with you. I know there was some discussion about sentencing powers. I wasn't convinced by that. However, I will say this. I think that sometimes this idea that PCCs have no potential reach into the police because of operational matters is, I think, overdone. I think when it comes to the timeliness within which police conduct their investigations, I think PCCs and others do have a role. Because frankly, we've tried in the past, through reforms to police bail, to really get a sense of timeliness for which the police should do their investigations. We then ended up with this release under investigation process, which frankly made things worse, and that was an unintended consequence. And there's no real accountability there. Now, we know the police are hard-pressed, we know the technology is proliferating, but we need a sense of timetable in order for defence solicitors, victims, everybody to have a greater degree of certainty, long before it gets to the door of the court.
Thank you. And Michael, Laura, did you have further thoughts on that issue?
I think you're reaching into the courts rather. I mean, I think there's a big piece of work because a lot of roads do lead back to the police station as to what's going wrong in our criminal justice system. And to be fair, we are working much closer now with the police and with the prosecution to ensure the process is more joined up. But it's very difficult. It's very tempting to say that ministers should be able to interfere in how the courts is. I mean, I'd love to be able to. But on the other hand, if I said to the judges, hang on a minute, why are you only sitting in court for 3.5 hours a day? I want you to sit 4 hours a day. That sounds reasonable. I can squeeze productivity. I can get more cases through. I'm a stato. I'm happy. However, the danger is then, do I end up with judges rushing cases through just to keep the political masters happy? And that's the tension that we have to judge, is having the independent judiciary. We can, if you like, take the judge to water, but I can't make him drink. In terms of saying, well, that's odd, productivity in that circuit is a little bit low, and leave it there. If I start to interfering, putting judges under pressure to see more cases more quickly, the danger is the quality of justice suffers. And that's the tension that on the whole works. Doesn't mean there's work to be done, but I would resist being able to reach into the courts and fix it directly, because that would change the balance, I think, in a wrong way.
Thank you. Another question.
Thank you. That was really interesting. My name's Romilly Dennis, and I work with BEAM, who are essential social enterprise helping ex-offenders back into work. My question is to Sir Robert. I was very interested that you said that each department needs to see themselves as kind of criminal justice department. Completely agree. But what more needs to be done to make sure that the work programs are truly integrated? Because you're seeing a lot with health and DWP, for example, but do you think enough is done between, and it's to all the whole panel as well, but do you think enough is done to make those programs truly integrated, or would you say there's still those silos that exist?
Yeah, I think the issue is still there is not that link, that sufficient link with business and the economy. I think there's some great initiatives that the MOJ have sponsored over the years. I'm trying to remember the name of the one that we were working on with regard to identifying need and placements. I think the reality is there's still too few actually permanent solutions. You're one of a number of charities. I work with Tempus Novo that do an incredible amount of great work in this area. I was with them last week. They are saying the same thing. They're saying, look, can we be helped to link up with more businesses and organisations out there? And I think that my advice, to friends in the MOJ now is, look, we've got shiny strategies, all very nice. Just get out there and actually, get businesses in, talk to businesses, use other businesses to help. We've got a whole range of great organisations from Timpson's right through to Sainsbury's and others who do this well. It's not, it doesn't have to reinvent the wheel. And then I'm just going to make a shameless plug for my publication and my review into autism and employment tomorrow. There's a clear criminal justice element to that. The employment gap for autistic people is shocking. It's only 3 out of 10 are in any form of employment. That, I'm afraid, is not acceptable. And again, this is all about facing business and industry to get them to adopt best practice. With a common guide or a common index, if you like, we can build confidence and we can see business and industry doing what so many do successfully and knowingly employ people with previous convictions have often proved to have turned the page and be the best employees that they've had.
Thank you. Do any other members of the panel have any sort of further thoughts on that particular topic? Laura.
Yeah, I was actually going to say that I think one of the things that has been very successful in relative terms is the employment rate of former offenders. If you look at, for example, things like employment advisory boards, which are now quite widespread across prisons, and they bring the bosses of big companies. One example, I think Greggs have got a representative on there. The number of people, I think just in the time that I've been an MP, who are leaving prison and finding steady work, and I think that's defined as a job that that they're still in that job 12 months later. Yeah, it has actually more than doubled, and it's around about 28-30% now. So I actually was talking to Charlie Taylor, who's the Chief Inspector of Prisons, and he's politically neutral and doesn't pull his punches when he wants to, but he actually agreed that he thought one of the really important and successful stories of prison reform that was happening at the moment was that there's really significant progress in the people who are making it out of prisons and into steady jobs. And that isn't easy for all the reasons that Robert gave. If you look at the average literacy level of a prisoner in this country, the reading age is 11. And the other thing which Gareth Bacon, my colleague, will talk to you about, I think, later, but one of the things that's also really important about the government's work on trying to avoid custodial sentences of 12 months or less is that when you look at the kind of prison programs, whether that's a literacy program or that's a work skills program or even just an addiction program, which is a really important part of getting yourself ready for work, if that's your difficulty, we know that they work least well on people serving the shortest sentences. In fact, the people who benefit the most from prison training are there for longer because those programs can reach them and help them develop. And actually, there's lots of reasons why short custodial sentences aren't a good idea, and I won't go into them all, but one of them is about employment. If the person has committed a reasonably low-level crime, keeping them in their community, relatively rooted to the people and the people around them, actually gives them a much better chance of being a productive member of society when their punishment is complete.
Thank you. And I think we have time for one more question. The lady on the end there, I know you've had your hand up for a while, so...
Thank you very much. My name is Davida Ademuyiwa, and I'm a councillor from Basildon and Billericay, Conservative councillor. My question, I had 3 questions and I can shoot them very quickly. The first is to do with the family courts and the criminal courts. There doesn't seem to be enough talking between the two courts, especially when it comes to victims of, let's say, domestic violence. They're in the criminal court and in the family court. And in the criminal court, the perpetrator is a criminal. In the family court, they're not, and it kind of skews justice. The second one is so it's all about access to justice. The second one is that with it's a legal aid one. There are quite a number of people who are like middle income, and they can't access.
Madam, I'm going to have to ask you to sort of make this your last question and speed up slightly, because we are slightly tight on time. Apologies to be rude, but obviously.
So it's what, because a lot of people have self-represented, including myself, and I found that most people who do that do not get justice. So what are the mechanisms to make justice accessible to everyone, not just the wealthy or not just the poor?
On the legal aid is quite quick. We've just completed a review of the means test in legal aid. So the threshold on disposable income is going to virtually double. We're taking out the disputed assets out of the calculation for domestic violence cases, and we estimate that will bring another 6 million people, particularly those in what I call the squeeze middle, will become eligible for some form of either help with fees or legal aid.
Thank you. Norman.
Probably the less said about legal aid, the better. We'll be here all day, unfortunately, and I know it's quite a contentious issue. But on the question of the courts and liaising with each other, I'll give that is hugely frustrating for us, and we're very often involved, particularly in domestic violence cases, where there are cases proceeding through the criminal courts at a snail's pace, and the family judges are becoming quite impatient with us. And in fact, only this week we received a demand from a judge in the family court wanting to know the outcome in the criminal case and place an order on us as the criminal solicitors to disclose that to him, understanding fully that we have a duty of confidentiality to our client, but also that that's public information, and the judge can actually just go and get that information himself from his colleague who is also a judge. So it is frustrating as to why there is any need at all for them to come through the solicitors and not communicate with each other. And of course, things are going at different paces, and it's very difficult to explain to defendants why it is that they have been acquitted of matters in the criminal court but still facing a finding of fact hearing in the family court. And wouldn't it be great to just have one hearing that dealt with all of the, if the issues are identical, can we just have one hearing? But yes, I do take that point. There's still quite a lot of work to do on that front.
I think your point is well made. Mike's made the threshold point, which is huge. But I think fundamentally, too many harms are being perpetrated in the family courts, and the family judges themselves recognise that. So a few years ago, the Family Harms Report was published by a committee chaired by Mr. Justice Stephen Cobb. Domestic abuse perpetrators are using Children's Act proceedings and indeed ancillary proceedings as methods of abuse, which is why we stopped the cross-examination in person of particularly victims, women, by their perpetrators. I think, frankly, and the President of the Family Division is great on this, Sandra McFarlane, we need to move away in the family courts from this adversarial process, which does not put the child at the heart of it, despite the Children's Act now being 35 years old, and have a much more inquisitorial process that frankly takes out that confrontation and reduces the risk of harm being perpetrated and continued against victims of crime. Now I think the government are very keen on this, and I think we've just got to redouble our efforts to make that happen. And then finally, I remembered what the organisation was. The New Futures Network is the MOJ employment network, which is great, but it needs populating and it needs more energy into it.
Well, on that note, it seems, to quote New Labour in Circa 2001, much done, much still to do on tackling the problems within our justice system. But for the time being, ladies and gentlemen, can I ask for a round of applause for our wonderful panel? Thank you very much for attending. I believe that there are refreshments available.